Let's separate. Straight answer is that her waiving of her right would not automatically result in a public hearing. That's the straight answer. Because when you look at the phraseology in Article 146, I think it's clause 8, it doesn't appear that...
8.
Yeah, 1468. But did I mention a different?
No.
Oh, okay. Yeah. So it doesn't appear that it's meant to protect her alone. No, let's read it. This is what it says. It says, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer, blah, blah, blah. Yeah, so from the way it's been phrased, it's not clear that it's only to protect the accused in a way. When I say accused, so that we can, effective communication. It's not a criminal trial, but for a lot of people.
You are using it in the loose sense.
Yeah, in the loose sense, so that we can communicate effectively. We don't gain anything by using big words when we can. Yes. So I'll use accused freely. Yes, I'll use accused freely because
this bit.
If in certain jurisdictions, so you see that even in a criminal case, they don't use the word accused. They use the word defendant, whether it's a criminal case or a civil case, right? All right. So looking at it, you can see, and I've expressed an opinion on that. I also agree that the proceedings should be telecast live.
The hearing of this 5-member committee.
Yes.
And the petition.
Yes.
You support the call that it should be telecast live.
Live.
Even though the constitution is explicit that it should be in camera.
Yes. So right now what we are saddled with is the language of the constitution. And I don't have the last word on it. So my opinion that it should be telecast live, please, it's not, what do you call it, the meaning of the constitutional provision. It's my personal opinion. As I've told you, my reading of it, it doesn't appear that it's only meant to protect the accused person in this case, but rather it appears it's for the whole of the system. There is still, though reduced, myth around the justice system, judges, the wigs, the gowns, and generally, our society is still evolving, so we accord a lot of, extra high value to the justice system and all that. So you can see that on matters concerning judges, we want to be sure that things don't come out in a manner as would make the public lose confidence in the justice system, etc. So you see that based on this history, etc., it doesn't appear that it's only meant to protect the person who has been accused, but it's also meant to protect and especially maintain the confidence that the society has in the judiciary. And it's not only the judiciary. You see that this provision 146 also applies to a number of the independent constitutional bodies. I think immediately I can remember the electoral commissioner. Yes, we are going to remove the electoral commissioner.
The auditor general. All of those.
Yes.
People,
so you see that.
Yes. All of them are subject to this.
Very good. You say it. So, and the independent constitutional bodies, there are at least about 7 of them in the constitution, right? So you see that this provision is meant, we're looking at those days, 1992, the way our society was, we're not that much enlightened. Even today, yeah, we are still far behind, right? But at least we've made substantial progress. So in matters like that, even if you want to test how sometimes people can get angry, you remember, okay, let me not cite the example, we've moved on. But generally, you can see that this constitution was written more than 30 years ago. The society at the time was what this constitution reflected. But now we as a people, we've moved on. Yes, we've moved on. The train has left. So the constitution now has to play catch up. That much is very clear. This constitution itself has been very clear that it's no longer fit for purpose. The design, everything is no longer fit for purpose. So thank God President Mahama has set up the committee. For 8 years, Akufo-Addo would have none of it. That's why JM would always stand tall above Akufo-Addo. I'm like, come on, a lawyer, 8 years, tweak this constitution for us. No. He wanted all the power, all the trappings of power. Yes. So moving on, yes, my heart is with the call for a public broadcast, public telecast of the proceedings. But when you look at the text of the Constitution, it's difficult. So maybe somebody should go to the Supreme Court, though it's difficult, you never know. You never know. Because, so I was saying something extra, that how about us looking for more innovative ways to make the argument? So number one, can Musa Dankwa conduct a poll on this matter again, so that we are looking for other arguments? If we conduct a poll and you see that over 60% of the population say we should do it live, that will add to the calls for the system to do something.
And you balance it out with that concern that you yourself underscored, that this in-camera provision was not born out of oblivion. There was a reason why.
Yes.
To, for instance, protect the identity and also the sanctity of the entire process.
Excellent. Yes.
So if that's the case, even if the public is making that demand, would the public demand surpass the intent
it appears so
of the provisions of the Constitution?
Yes, it appears so.
The framers of the Constitution.
It appears so. That was the argument I made, that as a society we've moved ahead of the Constitution.
Yeah.
Yes, the transparency, the calls for transparency have grown louder than this constitutional provision. The society has clearly moved on. So where you have society move, and that's one other area where you see issues of morality coming in. Sometimes society advances ahead of the laws, and so the law have to be amended to be able to catch up. This is one clear case where you see society has moved on. That no, listen, and that's how come you see the petitions leaked. The petitions leaked. People have read. We will not discuss here, but people have read and have made judgment. So we should stop playing the ostrich. Rather, we want to see how cross-examination can demolish the things we've read in the petitions. You see it. So that's how come there is a higher call to see the proceedings, because you're like, we've read on paper X, Y, Z. Of course, we will not mention the details. So, what kind of cross-examination is going to undo these things that we have seen in black and white? So let's do that thing. So Musa Dankwa should do a poll on this question. Number 3, we can also look at maybe demonstrations in favor of a public broadcast. Yeah, when the society makes a lot of agitations, asking for something, because justice emanates from the people in Article 125. So if people say that, look, our sense of justice today is that this thing must be made public, and after all, even the Chief Justice has also waded in, it will add. So we are adding all the arguments. Let's read briefly. It says that Article 125, Clause 1, it says, justice emanates from the people and shall be administered in the name of the Republic by the judiciary, which shall be independent and subject only to this Constitution. Then you see 1252 talks about participation of citizens in the justice system. So you see the assessor system and then the jury system. So the argument I'm making is that to the extent that it appears the majority of the people think that the justice in this case requires that it should be publicly broadcast, I think we should look at it well. Then, you see, this one is called shaking the kaleidoscope. Shake it, keep shaking. You don't know what you get.